Today, the Supreme Court heard 80 minutes of argument in the King versus Burwell case that is very likely to determine the fate of the Affordable Care Act. Now, we're not going to know until late June, or possibly even early July, what is going to end up happening to Obamacare. But there's the possibility that between 5 to 8 million people could lose the subsidies that allow them to afford health insurance in 36 states. And again, we're not going to know for quite a while what ends up shaking out in the Supreme Court, but we do have some quotes from the argumentation, the sorts of questions that various Supreme Court justices were asking. And so we are going to preemptively analyze some of them and perhaps render not a final judgment, but an early judgment on what's likely to come down for the Affordable Care Act. Now, the entire case basically hinges on a linguistic slip-up in the original construction of the Affordable Care Act, where they said that subsidies would be available to those people living in states, living in places where insurance marketplaces were established by the state. Those are the 4 words that you're going to hear referenced in multiple conversations about this. It's established by the state. Now, what the people trying to take down Obamacare, led by Michael A. Carvin, the man who led the challenge back in 2012 over the individual mandate, he says that that means that you have to take away subsidies from those nearly 36 states. Now, those who support the Affordable Care Act say that the clear meaning of those words is that whether healthcare.gov sets up the insurance marketplaces by the federal government or the states do, subsidies can be made available. And that seems to be very clearly the case. The Obamacare would not be affordable, it would not be sustainable if that was not the interpretation. And so we now have a case where the Supreme Court is going to have to decide which of those two sides take. And as we said, we're talking about the health insurance affordability of millions of people and possibly the structural, I guess, integrity of the entire law being taken down if they were to strike down subsidies for people living in those 36 states.
Okay, so first of all, 7.5 million people, roughly, could lose their health insurance, boom, overnight with a Supreme Court decision. Okay, now that's enormous. Now, as to the who's right, who's wrong, well, it's a mixed bag. So I think the language is fairly clear. It says the states should do it, okay?
Well, it says established by the state.
I know. So now you could make the argument, hey, the state could mean the government, right?
Well, we do use the word state synonymously with country, with nation very often. The state can be the United States itself.
My guess is that they use the state in that rest of the bill to mean the states.
I would, yes,
okay.
I think that's probably the case.
Plain devil's advocate. There's some plain language supports the conservative version, I believe. Okay. Now, along with the plain language, oftentimes conservatives will say, we were trying to find the original intent. Intent. And so Scalia has said that a million times in a million rulings, and he always says, they will say things like, Madison and Jefferson couldn't have possibly been talking about the 3rd trimester. Roe versus Wade is ridiculous. It goes against the original intent of the framers.
Yeah.
Now, in this case, the original intent is abundantly clear because they didn't write the law in the 1700s or the 1800s. They wrote it a couple of years ago. All the original framers of this law are still around. You ask them, and they all say we meant the states or the federal government.
Yes.
That was our intent, and there is no dispute over that. The context of the entire bill leads you to that same conclusion.
It has to, because they would not have set up a law that would have crumbled under its own weight after 2 or 3 years.
Right. So if you took the context, which is exactly what you should do, figure out what was their intent, you would get to they meant the states or the federal government. But you don't have to take the context. You could just ask them, including Republicans who were on committees saying, yeah, well, obviously we meant states or the federal government. That was so obvious, right?
Well, here's how obvious it was. This was not something that was being debated at the time. There was strong, obviously, if you were around, there was strong opposition to Obamacare. It had nothing to do with this. Nobody on the Republican side noticed this for a couple of years after the law was actually passed. So, you cannot say that they meant anything other than what the defendants are saying in this case.
And then there's a great irony here that conservatives would be trying to overturn Obamacare under a technicality.
Yeah.
Because they're always like complaining about that, right? Ah, the criminal got away because of a technicality, right?
This would be to them a frivolous lawsuit, I believe.
That's right.
Which they say they're against.
Right.
Look, you can disagree over policies. You can disagree over whether or not the individual mandate is fundamentally constitutional. The Supreme Court says it is, but you can debate that. But you also have to bear in mind the consequences of changing the law at this point. If 7 million people lose health insurance, what percentage of them will fall ill without any treatment? What percent of them, what raw number of Americans will die as a result of losing their health insurance in what is effectively a game of political checkers going on here? They're playing games with people's lives. Now, we always throw that term around, but it is literal in this case. 7 million people, many of them will die if their health insurance is taken away at this point. Now, the first thing that I want to bring up is from Judge Anthony Kennedy. And now this is very important because we believe that the swing vote is either going to be Justice John Roberts, because he was the swing vote in 2012 when the individual mandate was being analyzed, and Anthony Kennedy. So he says here, in referencing those 4 words that I talked about before, that your argument raises a serious constitutional question. He says, can we actually have a situation in which the states are being sort of forced, their arm is being twisted to set up this exchange or possibly losing some sort of tax incentives and things like that? So that is, if you want the Affordable Care Act to continue, that should be worrying for you. We also have him saying here, the states are being told either create your own exchange or we'll send your insurance market into a death spiral, basically summing up that line of thought. And it's entirely possible that other justices agree with that idea. But you do have Justice Elena Kagan saying, we don't look at 4 words, we look at the whole text, implying there that she, at least, will be looking at the entirety of the bill. And Justice Stephen Breyer says, if you want to go into the context of the law, at that point, your argument really is weaker. So, but those are considered sort of safe votes for the continuation of the Affordable Care Act.
I want to go back to this issue of the technicality, okay? Because, all right, let's think about this. No Republican actually voted for this bill in the Senate, okay? So it was all Democrats. So you have to look at their intent. Yeah. The intent of the people who voted against it are to kill it and not to pass it at all. So you have to look at the intent of the people who passed the bill. If you ask those people, they are unanimous. Every single one of them says the intent was to create this insurance exchange either by the states or by the federal government. Yeah. So I would like the Supreme Court justices that are the so-called liberals, the Breyers and the Sotomayor, Kagan, et cetera, to turn around to the conservative justices and get them on the record. I know that this doesn't really happen in public.
There's no gotcha questions.
Right. But they do have internal conversations behind the scenes. Yeah. They absolutely do. They do deliberate in that way.
They're sometimes interviewed as well.
Yeah. And I would like them to ask the Scalias of the world, are you saying you are forever giving up on the principle of original intent?
Yeah.
So so you're going to promise me 2 things. One, you're never going to mention original intent ever again in any case, because you are saying here definitively that you don't believe in original intent. Because I have 100% of the people who voted for this bill saying their original intent was to do this, and you're going to vote against that.
We can call them up right now if you want to.
That's right. Okay. Now, and I'd like a second thing, just because I know you're a principled guy. I mean, that's what you built your whole reputation on, right, Scalia?
Scalia,
principled, right? Okay. I would like you to go back and say in public, I was wrong in every single case that I ever mentioned original intent. I'm so sorry. Obviously, if the original intent is 100% clear, I still don't give a shit, okay? So I was lying or I was mistaken in every one of those cases, and you should reconsider those cases.
I mean, unfortunately, we don't have Scalia. They did ask Thomas that, and he was quoted as saying...